So you were talking about advertisement of attorneys before we went on the air, and we came on the subject of some gaudy ones that we've seen before. Now, you've been to Florida before, but you haven't noticed the signs down there.
No, I never noticed the signs.
Oh, my God.
I was too
man.
distracted by, like, alligators crossing the road.
Yeah. Well, okay, that would distract anybody, yeah. But, Maria, my wife, is from Florida, and I go down there at least once or twice a year, and they don't have any qualms about advertising down there, man. And, you've probably seen the movie or the guy who's Just Call Saul.
Yeah.
He's got his attorney's office in the strip mall, and his signs are all over the place. That's what Florida looks like. Most of those attorneys' offices are down there. Sorry, Florida attorneys. I'm sorry. I shouldn't be speaking like this, but it's true. You go down there, you go, oh my, this is like unfettered. They could advertise any way that they want. But you said something else about Florida, and I'm going to bring it up. I'm sorry, but you've been to Disney World 2 times in your youth, and you walked away with, come on.
I'm not a crowds person. Pre-COVID, I was not a fan.
But you were a little girl. Come on.
Well, to be fair, I was in my 20s when I went to Disney World.
Oh,
so
okay.
I wasn't, but when I was little, I went to Disneyland a few times.
And then you're off the hook there because you do experience it differently when you're an adult. When I moved out here to California, all my childhood, all the privileged kids, we went to Disney World or we went to Disneyland and they got all this stuff. And then my older siblings went there and I was always the one that didn't go. So I come out here, I'm a cop and I go to Disneyland and I'm like, I don't like the crowds, and it's a little bit colder out here than what they said it was. And the area around Disneyland at the time, it's not like this now, but there was a lot of seedy hotels and all this stuff. And I'm going, okay. But I'll tell you what, though, I brought my kids to Disney World and Disneyland. And I'm going to tell you, Disney World was better.
Yeah.
Okay. Monty, you haven't been there, right?
No, not to Disney World.
No. Okay. Well, they got like 8 campuses, and you take a bus from one to the other and you stay at their hotels and you're still in the theme park. And to me, it was really fun. The only thing I would say is my kids were tuckered. They were so tired. They were begging us to go back to the hotel. And we're like, no, let's do more. We're going to get our money's worth, right? You got the water parks and all that stuff.
Animal Kingdom and all these. Yeah, I think there's 8 parks.
Yeah.
So it takes like a whole week to get through everything.
And I guess they're redoing Epcot during this COVID thing, and they've added to that. And that was the most spectacular thing I've seen of any of the Disney stuff. So maybe someday we'll all go as a firm. Wouldn't that be nice?
Let's do it.
Okay. So COVID-19, right? Vaccines are coming around. What are your thoughts about it, Mane?
Well, I did read an article that President Obama, Bush, and Clinton are lining up to say, hey, look, we'll do it to show you guys it's safe. I don't know. It's kind of scary.
Really?
It's still very experimental. So I don't know. But I think it's great. I think they said that by January, they should have like the trial ready to go. And I think it's first going to go to senior citizens and healthcare workers. And then it'll become available to the public. So, if it's available, I'm sure.
I know what you're thinking. By the time they get to me, man, they'll be tested. I'll be good to go.
Exactly.
By the time it hits target, man, all these other people have been the guinea pigs, man. I'm good to go.
Yeah, I think they're actually starting in the UK with some trial runs. So by the time it gets to us, we'll see what's going on over there.
See if there's still a Britain left after that. Yeah. You know what's this sounds very horrible, but maybe we should have cards. Hey, either vaccine or not, or you've got the antibodies or not, and that would allow us to go where we want to go. I'm going to tell you right now, I'm first in line, man. I'm getting it. I don't care. I think that, people are so afraid of vaccinations, but we get them all the time anyways, right?
I think it's a huge, issue with getting the population to actually get vaccinated. We've had the flu vaccine for years and it's very effective, but the amount of people that actually get vaccinated is very low. I think it's very, very less than 50%.
Oh my God,
very
I didn't know
low.
that.
Yeah, there's a documentary on Netflix.
Well, is it because people can't afford it? Well, actually, it's usually free.
Yeah, it's usually free. There's a lot of organizations that travel to poorer countries and they hand them out for free. Even in the U.S., you go to CVS, you can get your flu shot.
I got to tell you, when I go to court, when I was going to court, without doing the court call, because now we're doing most of the things on phone, and the court system apparently is shutting down again, where from what I'm hearing, is that they're really discouraging you to go into the courthouse. But the times that we were going, and I've gone with both of you to the court during COVID, it's kind of like you feel like you're taking your life in your own hands sometimes when you do that, because God, I mean, it's like you got anybody and everybody that's hovering around the court going in there. So.
It's a bit scary being in the hallway waiting for you to get called, or if you see someone inappropriately wearing their mask, you kind of want to say, "Hey, wear that correctly," but you can't.
Yeah.
So yeah, it's a bit. I mean, there's face shields, but they're so ridiculous looking that I wouldn't take myself seriously.
I'll be honest, I've never gotten a flu vaccine.
Yeah, me neither.
But I definitely will be behind Dawn in line for the COVID vaccine.
Well, I'm thinking about ladies first. I mean, is that okay?
I'll take it.
Okay, so we're going to talk about some serious stuff today, and we thought we would bring in the end of the year discussion of the domestic violence cases. Stephanie, last time you were on the podcast, you talked about a case, and it was really interesting. It was about a woman who thought she was entitled to a domestic violence restraining order. The trial court said, and then she took it up on an appeal, and the Court of Appeal went like that as well. So we got some other ones here. Then I don't know how you're divvying them up. I should say this, is the two of you are good friends. Your offices are right next to each other. You collaborate on everything. I don't want to say you conspire on everything, but, I told you, just tell me, you pick your cases and you tell us. So who's going first here?
I could go first.
Okay.
So yeah, we read the cases. We kind of talked about a common theme amongst each other between all three cases that we kind of went over. So I guess I'll go through the shorter one first. It was the marriage of Ancola case. What year is this?
They're all 2020.
This one's 2019.
It is?
Yeah, it says 2019.
Ooh. You know what I think? I think I received it right at the beginning of the year, but I received it in 2020, but it was published in 2019. Okay, tell me about Ancola.
Still pretty recent.
Yeah.
So this case dealt with, obviously, domestic violence, and basically what had happened was wife had obtained a permanent restraining order against the husband, and a couple of months later, the husband filed his own request against the wife. Hers was granted in June of 2017, and then in August, so 2 months later, the husband filed his own. There was a hearing, and the court had, there was a long trial, and the trial court actually issued what's called mutual restraining orders. So even though husband was the one requesting the second restraining order, the court again issued a restraining order protecting the wife.
So it kind of reissued the first one, but it was a new one.
Correct. Okay. It was a new one. So husband then appealed the issuance of the new restraining order protecting the wife.
Because? And what was his claim on appeal?
So his claim on appeal was that the trial court made an error pursuant to Family Code 6320, which states, which has two prongs. The first prong states that in order for a court to grant a mutual restraining order, both parties must be present and they both must have on file their own requests for a restraining order. So the Court of Appeals affirmed on the grounds that the wife, while she filed a response to the husband's restraining order, she did not have her own application on file. And because of that, the trial court didn't have the discretion to grant these mutual restraining orders.
The trial court was reversed.
Correct.
Yeah, because in essence, wife, if you wanted a restraining order, you needed to file it again. You can't just coattail off of the first one that you got against
Correct.
him, right?
Well, the first one was still in effect.
Yeah.
That husband was appealing that one as well, but the appeal was pending, so we don't know what happened with that one. But yeah, thinking about it now, I mean, there already was a restraining order anyways against the husband. So
I just think that it's a good lesson for us when we go into court to know that if you want a restraining order, you've got to ask for it. You can't go into it as a defendant, and say, Judge, you know what? Look, there was evidence that, she slapped me on the face during this incident. So what's good for sauce for the goose is sauce for the gander, right? I know you're making faces. I thought I would say that so they get that reaction from you. So, you can't say that because, the code is pretty clear on that, right?
Correct. And, in the beginning of it's been almost 2 years since I've been practicing, I didn't know what a mutual restraining order was. And I did believe that that a court would be able to issue one even if you didn't have your own application. So it's good to know that you have to satisfy both of the prongs under 6320 to get your own restraining order.
Yeah. In the old days, they used to do that before the code was amended. They'd go, I'm going to make it mutual, and they're like, no, you don't get to do that. So cool. Okay. What other case are we going to talk about? How many do we have here today?
We had about 10 cases today.
Okay. Well,
but the one that I will be discussing is Curcio versus Pels.
Okay.
So it's not a paternity action. It's not a divorce. It's two women who were in a relationship, and one of them filed a restraining order against the other. So let's see, they dated for about 2 years, and the relationship ended in 2016. And about 2 years after the relationship ended, one of them filed a restraining order. So both were comedic performers. That was a theme here, that they were both like comedic performers.
When I read this, I'm like, I want to go on YouTube and see if I can watch these.
I wanted to watch one of their like stand-ups or something.
I went over there at the Ice House here in Pasadena.
I found their Instagrams.
You did?
You did?
Yeah.
She's our private investigator. Okay, so Curcio is the one who filed the restraining order, basically alleging that, Pals had been physically abusive, that she had been kind of stalking her, following her at theaters. There was some sexual assault, that she had posted on Facebook this huge rant outing her. My partner physically, sexually abused me. If you hire her in any theaters or performances, you're basically supporting a rapist or an abuser.
Can you stop right here? Would we agree that there was a lot of venom in this relationship?
Yes.
Okay.
Yes.
So, and she was going for the proverbial jugular?
The jugular, yes.
Okay.
So there's this social media post. She alleges that she woke up to a blow to her head. So there was some physical violence there, that she was unstable. So we get to the hearing on the restraining order, and both parties are actually in pro per. Neither has an attorney.
Could you imagine that two comedians sitting at the conference table trying
to
keep a straight face as they're... No, go ahead.
Basically what happened, the court basically accepted everything that she put in the pleadings. They accepted it as truth and evidence. And then they shifted the burden, making Pels show that she did not commit these acts. So there was a weird shifting of the burden. So Pels had no witnesses. She didn't, examine Curcio, nothing like that. So the court granted the restraining order. So it was really, really weird. Essentially here, what the court found
Court of Appeal.
The trial court granted the restraining order because they found that the Facebook post disturbed her peace, that was a form of abuse.
And this is kind of the crux of the decision, right?
Right. So, okay, so then on appeal, the court found that this one private Facebook post, which happened to be the person's opinion, did not constitute abuse. It was not disturbing of the peace. Then they compared it to other cases where they did find disturbing of the peace. Someone hacked into someone's email account and printed all the emails, and they hacked into their phone and got some text messages.
Weiser versus Sweeney, was that one of the cases they talked about?
Right. And so in comparison to those type of situations, this did not constitute disturbing the peace. So the Court of Appeals did reverse the order, and the restraining order was dismissed.
I read the decision now. I can't remember. Was there a constitutional analysis about First Amendment rights in this one?
There was a speech restraint issue, but the court didn't go into that because they found that it wasn't necessary.
Okay.
Yeah.
Because you know what? It's funny. I breezed through that decision, and I think I assumed that there would be a First Amendment issue because we know on other cases where a trial court has said, "Sir, you better not post anything more on Facebook about your ex-wife."
Right.
That was found to be unconstitutional and reversed. Here, from what I understand, is she was posting on her personal, private Facebook
account.
So it's not like the public knew about it.
Right.
It was people that she knew. It'd be like having a conversation with a group of her friends, right?
Right. And so it was odd because the trial court found that by posting that Facebook post, it was interfering with her ability to find work, to support herself, and that's how it disturbed her peace. But the Court of Appeals, found no, that's one post, it's private, it's not.
It'd be different than if she was standing outside the theater as she's going into audition and she's, following her in and saying all things, as she's walking behind her and going up and interfering with it. But this is like a freedom of speech issue to me. But it wasn't really decided on that issue. It was more like this one single incident.
Right. And then also they reasoned that the trial court made an error in shifting the burden. That first they should have put the burden on the petitioner, the one bringing the request.
What a novel thought.
Right. To put the burden on her to prove that there was actual incidents of abuse.
You mean that big rubber stamp that court has sometimes just isn't constitutional? Is that what you're telling me?
No.
Okay. All right. Okay. So I guess there's some due process in family law.
Exactly. Due process.
Okay.
There was also, I wanted to add one last thing. I thought it was hilarious that the judge ended up adding, and this was reversed also, he added an additional year to the restraining order because he felt like she wasn't taking responsibility.
Yeah. She wasn't like admitting.
Remorseful.
Yeah.
Remorseful.
I'm going to add an extra year.
Yeah.
So that was also reversed.
I forgot about that. So you know what that smacked of is I know where that judge came from. That judge probably was a former deputy DA like myself and had been doing criminal cases for a long time because there you're always looking for remorse.
Mm-hmm.
That's something that always goes in with sentencing. And I think this judge crossed hairs there. It was like, for one thing, this isn't a criminal case. And two, if you think that she's being disrespectful,
right.
What's the remedy for that? Contempt of court, right? I mean, I could hold you in contempt, but instead, I'm going to add another year and say, pipe up again. I'm going to add another year. It doesn't work that way in family law, right?
Right. There was no legal basis for that.
Yeah. Now there is a basis for adding time, and that is how egregious the incident was, or how bad the domestic violence was. Then the court could say, well, at my discretion, it should be a 5-year. But I don't like your attitude. I'm going to slap on another year.
It's not enough.
Okay, so that's a great case. What else do we got? Anything else on the menu here?
Yeah, I was just flipping through the last case.
Wait a minute. She said there were 10 cases. I'm just getting going here.
This was the marriage of Everend. This is from March of 2020.
Okay,
recent.
so at least we got a 2021.
Although I don't know if it was approved for publication.
Uh-oh.
But very similar to the first case that I was discussing when they go through 6320 and the 2 prongs, and basically this focuses on the second prong. It dealt with a mutual restraining order. So in this case, both husband and wife had filed their own restraining orders. So the court held one hearing. It was a multi-day evidentiary hearing where a lot of evidence was presented, police reports, testimony, a lot of evidence. I think it was 3 days or 4 days. And a husband appealed the restraining order. So the court in the end ended up granting mutual restraining orders against both husband and wife. They were to keep away from one another. And husband filed an appeal, but this time it wasn't focusing on the first prong, but rather the second one, which states that the court, in addition to, finding that there was applications filed by both parties, the court also has to make detailed findings indicating that both parties acted as primary aggressors and that neither party acted in self-defense.
Okay, let me stop you here. So this is really interesting to me because, as Stephanie and I have discussed this before, is we're getting really into minutia now with these domestic violence cases. When I started practicing, 2 centuries ago, there were no published decisions on domestic violence cases. Now what we're getting is this every year a plethora of new cases coming through, and they're examining issues, kind of like how they do in criminal law. If you ever practice criminal law, there's so many new appellate court decisions. You just can't keep up with them, and they're just nuancing. Mm-hmm. Now we're getting into the domestic violence restraining order cases in family law, and this is a nuance that I did find a little bit interesting. And so go ahead. I just wanted to put my 2 cents in there.
Yeah, I mean, as a young attorney, I like that because a lot of the cases are like case by case, very like specific facts. Then I found some of them very similar to the cases that we deal with today, especially the ones that deal with disturbance of the peace rather than like physical abuse. So yeah, keep them coming because it's helpful. Although,
it is helpful.
Yeah, it's helpful.
It's helpful. So In this case, the Court of Appeals did not agree with the husband because it did find that the trial court did make sufficient factual findings regarding the fact that neither one was the primary aggressor and that neither one was acting in self-defense.
So he's complaining. He's saying, you know what? There shouldn't be a restraining order issued against me. And he's basically arguing a technicality. He's saying this trial court didn't make an adequate factual finding that I committed domestic violence on my wife.
Correct.
Because the code says that you have to make a factual finding. So what did the Court of Appeals say?
The Court of Appeals said that the court did make detailed factual findings about the abuse. There was a police report presented, 2 police reports. There was a police officer who testified. It found wife to be credible, based on her body language, the way she spoke about the incidents, things of that nature. There was a lot of history. Husband had a history of drinking. So ultimately, the trial court did a good job of making these factual findings when it rendered its ruling.
Good enough.
Mm-hmm.
The way that I read this is that the factual finding was good enough because it led the Court of Appeal to the record to see where it would happen. So like the trial court says, I find that there's been a long history of domestic violence in this case. And the record shows that there were witnesses that talked about those things, police reports and all those things that came in. So the way I read this decision is that we're not going to make the trial court get into a War and Peace description as to what happened, a 45-page, statement of decision as, well, he punched her there, and I'm going to find that was, it's basically you have to make the findings that these things took place and give an adequate roadmap or point in the right direction to the evidence. Is that right?
I agree with you because towards the end, the Court of Appeals makes a statement like, although there's a lot of authority on what constitutes detailed findings, the court is not required to go into it, like you said, pages and pages of facts that, it relied on, as long as it's good enough to satisfy the code.
So I had a case recently where I wanted to ask for a statement of decision from the court. And a lot of these judges, by the way, they're doing a really good job of that. I mean, I've had some of them, they just like, you don't even have to ask. They're like, and I find this and blah, 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 blah. And they're like, holy cow, man, that was superior. Even though I lost on that case, that was superior statement of decision. But, I'm tempted sometimes to ask, when it's a close call case, they ask for a statement of decision, such as, would the court make a statement of decision as to the factual findings that throwing a cake across the room is not disturbing the peace? I don't know if you could go into that. Or I guess they have to write the statement of decision. They've got to have factual findings, but it doesn't have to be as detailed as maybe we want. Right. So long as they've heard the evidence, right? Is what it is.
Yeah. Well, this makes me think of me and you recently had a case in the summer, and the trial judge did a great job of making factual findings.
Yeah, that guy right there. He should be on the Court of Appeal himself, right?
Yeah.
The way he wrote that thing. Yeah. It was like, I've seen a couple of those. I'm very impressed by the detail, that
they're really listening.
Yeah. They're trying to avoid some of that.
Well, that was fun. I just wish that you had a couple more.
All right, here we go.
Well, thanks again, ladies. It was wonderful, and we'll see you soon on the next turnaround. Probably in 2021, we're going to be coming across the COVID cases part 2.
Yeah.
How did you love that? Okay, thank you.
Thanks,
Don.